cases are separated. It doesn't make a ton of sense to me because the facts are so intertwined. The basis for her EPO was the assault for DV allegations. I think for judicial economy, and seeing as this has been going on for almost 2 years, with his motion to join, I think that at this point, it's only appropriate for us to join these two cases together and to hear them today.
Thank you. Ms. Mudd.
Your Honor, I understand Ms. Borders brings up a motion for a joinder. I never filed a motion for a joinder. I am unaware if Mr. Clack filed that pro se at some point. There was a period of time where he was filing his own motions before he was represented, and I think he even filed a few after he was represented, but we've never had a FREDA hearing. If there is a motion that has been filed for a joinder, I didn't make that motion. I don't know of the motion having been made. Now, I know that there was some discussion, and I had conveyed to Ms. Borders at one time that I thought that we should do separate trials, and that was what I was going to advise Mr. Clack, but that we weren't quite on the same page with that, so I wasn't sure. But I think that these were separate cases. They are separate cases. They're two different case jackets. They happened on different days, and I think that I didn't have any kind of burden to make a motion to sever because they were severed and they were never joined. So it wasn't like these were both charged on the same case. There's two different case jackets. They were never joined. As far as I know, there was never actually any motion to join them. Now, like I said, I may be wrong about that. Maybe Mr. Clack filed that. I'm not aware of that.
Do you want to briefly respond to that? Did he file a written motion, or was it just kind of discussed informally the whole time?
I think it's been discussed multiple times, Judge, and to be quite frank, there was a different prosecutor on this case before me, and there's been many pro se motions filed, and so I don't have that physical motion in front of me, but again, this has been our understanding from day one that we were going forward on both these trials today. The first I've heard about a possible separation was yesterday.
All right, so I'm the defendant. I was a pro se litigant at one point, but my attorney said that she wanted to separate the charges. I'm a pro se litigant. I never had a FREDA hearing. So if I did file any motion, you adhere to what my attorney told you, and that was to separate it. That's what my attorney said. And I personally do not recollect filing that exact motion. So for that information to be introduced to this new judge, who was, we didn't even see this Judge Wilcox until this day. She didn't have no right to make any decisions on this case. And all she did was deny every motion set forth by the defense and grant all the motions set forth by the plaintiff. So it was biased, and the judge was rigged, and I want to make sure that the court knows that I know this. So, yeah, overturn my conviction. That's the first thing. We're going to tackle that first.